Hey guys, welcome to this video. We're going to talk about how should your credit report show a mortgage account after a Chapter 13 bankruptcy. And we'll look at a recent case involving Carrington Mortgage and how they reported after Chapter 13 bankruptcy where the consumers said that they would surrender the property. So let's take a look at this. And I'll have this little short link in the description so you can read the case yourself. But this is Robert Morris and LaRonda Morris versus Carrington Mortgage. Now, they sued some other companies. Presumably, those cases have already been settled. And you can see here that this is a very recent case, April 23rd. So let's jump right into it. The plaintiffs say Carrington violated its duty under the Fair Credit Reporting Act, the FCRA, to reasonably investigate their dispute of the accuracy of information. So what specifically did they sue under? Well, they sued under this 15 USC section 681 S2B. And that's the section of the Fair Credit Reporting Act that says if you dispute with the credit bureau and they notified the furnisher, Carrington's a furnisher because they provide or furnish information to the credit bureaus, then that furnisher, Carrington here, must do a reasonable investigation. Now, Carrington moves for summary judgment saying we are not liable. And even if we were liable, there's no damage that resulted. Now, the consumers, the Morrises, they move for summary judgment, but only on liability. So they want the court to enter a judgment on liability and then have a jury trial on the damages. So here's what the judge finds. This is Judge Jennifer Dorsey here. She says, I find Carrington furnished incomplete and inaccurate information. But if Carrington is held liable, it's responsible only for the damages that occurred after its Fair Credit Reporting Act duties arose. And everything else we need to have a trial on. So let's see what happens here. The facts are not really in dispute. So the plaintiffs filed a joint petition under Chapter 13, 2010. And then 2013, the bankruptcy court said, look, you fulfilled all your requirements, you're discharged. And then we have 4 years after the discharge order, so that would be around the end of 2017, first of 2018. Ditech transferred the servicing rights to Carrington. And then 7 months later, the plaintiffs apply for a loan, and they discover Carrington's furnished information to the credit bureaus, Equifax, Experian, TransUnion. 4 payments, 90 or more days past due. Past due amount $67,000, and they owe $451,000. And foreclosure proceedings started. So, the final thing is Carrington did not say anything about the bankruptcy. So here you can read about the legal standard of summary judgment. It's basically whoever's moving for summary judgment is saying to the court, I'm right under the law, and there's no dispute of important or material facts. And so there's no reason to have a jury consider this. You can go ahead and summarily enter judgment in my favor. So this is typically I'll put what the judge is saying in blue, what Carrington says in green, and what the plaintiffs say in yellow. So to prevail under this type of claim, there's 4 requirements. Number 1, there has to be a consumer report that has incomplete or inaccurate information. Number 2, the consumer disputed that information with the consumer reporting agency. So again, Equifax, Experian, TransUnion, those are the big 3. Then the third element is the reporting agency had to notify the furnisher about the dispute. And then number 4, the furnisher failed to comply with its obligations to investigate, report, and correct inaccuracies. Now, nobody doubts or disputes number 2 and number 3 have been satisfied. So what they're really fighting about is number 1, does the report contain incomplete or inaccurate information? And number 4, did Carrington fail to do a proper investigation? So Carrington says, look, the information we gave, totally accurate, 100% accurate. And we reasonably investigated the dispute. And Uh, and this actually should be in green here, but they're also arguing the Morrises cannot demonstrate they were actually injured or suffered damages. So if, for example, you sue a furnisher and you can prove that they acted improperly, but it caused you no damage, then unless, and this is a whole different subject, unless you can prove a willful violation, then you would lose even though they would have violated the Fair Credit Reporting Act. So the consumers, the Morrises, say, hey, look, we're entitled to partial summary judgment. Remember, they only want summary judgment on the liability because the information Carrington furnished was inaccurate and it did not reasonably investigate their dispute. So let's see what the court says. Information is incomplete or inaccurate if it is either patently incorrect, I mean just absolutely incorrect, or it's misleading in such a way and to such an extent that it can be expected to adversely affect credit decisions. So what exactly did Carrington say? Well, he said, look, some of the payments, 90 days or more past due amount 67 grand, you owe 451, and foreclosure proceedings commence. So let's go back to the plaintiffs, the Morrises. They claim that's inaccurate to say anything other than discharge and bankruptcy with zero balance due. And that is correct, by the way. The argument they're making is correct. And they reason the information Carrington furnished was inaccurate because Chapter 13 discharge and a Chapter 7 discharge operates as a permanent injunction against the collection of debts to extend their personal liability. And so if you, as a furnisher, are reporting past due amounts, balance owed, that gives this false impression that I, the consumer, am still personally liable for that loan. Now, what does Carrington say? They say, no, there's no legal obligation to report a discharge on a credit report, and the debt remained due and owing even if no longer part of the bankruptcy. And so they rely on 3 district court opinions. So remember, district court opinions in the federal context, that's your trial court. That's where you have jury trials. Then the Court of Appeals is the appellate court, and then the next court is the Supreme Court. And now this judge is going through saying, well, actually, none of these cases work for you, Carrington. So we have this Vasconcello. It's distinguishable because it concerns the accuracy of information reported during the pendency of a bankruptcy, not after a bankruptcy discharge. And then you have this, I guess it's Jugos. I'm not sure if I'm saying that right, but misplaced for the same reason. And then this Bank of America case, similarly distinguishable because the plaintiff in that case did not allege Bank of America falsely furnished information that her debts were still due and owing after they were discharged. Okay, so the judge kind of gets rid of that. And then she says, well, look, Carrington now is changing its argument. They say, well, actually, the disputed information is accurate because guess what, Judge? Those loans were never discharged in bankruptcy. Kind of a shocking statement to make. So the court goes, well, let's think about this. Typically, there's an order releasing debtor from liability. This is the discharge order. And that's what the plaintiff's got here. Well, Carrington doesn't argue that there's some exception. So in other words, certain debts are accepted from discharge, typically student loans, certain types of taxes, maybe fraudulent conduct. And but Carrington doesn't argue that. They say instead, well, look, the Chapter 13 plan said the consumers have to surrender the property. And the loan wasn't discharged because they did not voluntarily surrender the property. So they didn't fulfill that requirement under the plan. So, and this is true in a 7 and a 13. You're asked about property. Do you plan on keeping it or plan on surrendering it? Now, the response by the consumers is, hey, you're attacking the discharge order. That's from another court. You're trying to attack that now in this new court because that discharge order said the debtors, the consumers, have fulfilled all requirements under the plan. And the judge says, look, you lose on this, Carrington. And then Carrington says, well, let me show you there's no surrender. They didn't vacate the property. They didn't give us the keys. They didn't quit claim the property. And the judge says, well, the plan didn't require them to do that. You're just making this up. You're adding stuff that the bankruptcy court never said. So it says, judge says, quite clearly provided that as to real property claims, this will modify the automatic stay so you can exercise your remedies. In other words, the plan put the ball in the creditor's court. Now, technically, that wasn't Carrington, that was Ditech back then, but Carrington has to stand in the shoes of Ditech if they truly got the loan from Ditech. So look, the ball's in your court. You've got to take some action. So what the consumer's doing is saying, look, I've give up my rights to it. But that doesn't mean they have to then go do things like hand you the keys, go get a lawyer, prepare a quitclaim deed, like drive to your corporate office and beg the CEO of Carrington Mortgage, please, please, please take our keys, take the deed. They don't have to do that. They just have to give up their rights, which they did. This is on Carrington. And look, this happens after a discharge. A lot of times the banks won't go take the property. And so they want to kind of hold that against you. And then, if you want to use the property, then they say, well, you have to pay us. And if you say, you know what, forget, I don't want the property anymore. They go, well, we don't want it either. So anyway, judge here does a very good job pointing this out. Carrington also says, well, look, here's why they didn't surrender it, because there was a foreclosure mediation and they wanted us to approve a short sale. So a short sale is, like in this case, I think they owe $452,000. Maybe they had somebody offering to buy it for $375, $350. Well, that would be short of the amount owed. And so since the consumers asked us to consider that short sale, they didn't really surrender. And the judge says, no. Those acts occurred years after the discharge order was entered. And so neither could have prevented the loan from falling into the discharge order scope. So Carrington has failed to demonstrate the loan was not discharged. So in other words, the loan was discharged in bankruptcy. And then here's a bankruptcy judge that explains, what does a discharge mean? So the debt remains, but personal liability and debt's removed. So liens on property remain on the property, and the creditor is free to exercise any non-bankruptcy collection remedies to secure its interest. So here's what that means. If I have a car, I go get a discharge. Well, I don't owe any money on that car anymore, but Wells Fargo or Bank of America or Toyota Finance or whoever it is, they can come get that car. Okay? They have the right to go get it. Well, same thing on my house. If I discharge a loan, well, Wells Fargo or whoever my mortgage company is, they can foreclose on the house, but they can't ever say to me, John, you owe this debt. I do not owe the debt. That's what the discharge is. And the judge also explained, security for a debt, real property is typically evidenced by mortgage or deed. And so now that's your right to go get the property, is because you have this mortgage on it. All right, what this means is upon entry of discharge order, the consumer's personal liabilities was removed. All creditors permanently enjoined against the commencement or continuation of an action, the employment of a process or an act to collect, recover, offset any debt as personal liability. In other words, creditors, debt collectors, any discharge debt, you better not do anything to try to get that money. Now, again, you can go get the property by following the rules. And look, some people, they get a discharge, they do not reaffirm the debt, and they stay in the property. Well, as long as you make your payments, typically the mortgage company will let you stay in there. So they may point out to you that money is due, but it's not money you owe. It gets a little weird, okay? You have to pay a debt that you don't owe, or they'll come take your property. But here's what's absolutely clear. They cannot say you owe the debt. That's exactly what these companies, and we've been suing these companies since about 2006 on this, where we get a discharge and then they report a balance. That is untrue. That's false credit reporting. When you get the discharge, you do not owe that debt anymore. Now, again, a lien on your car, on your property, on your tractor, whatever it is, that may still apply, but there's no liability. Okay, well, let's go back to the case here. So Carrington didn't furnish only information about security interest, which it still had. It also furnished information about the fact and amount of past due payments. Well, how can I be past due if I don't owe any money? Kind of hard to be past due. And the amount of the balance. Well, how can I have a balance if the debt's discharged? You can't. The amount of the balance that was owed on the loan. These items of information are badges of the existence of personal liability and can be expected to adversely affect credit decisions, so they are inaccurate. And there's also incomplete information because it did not include the discharge in bankruptcy. And so the judge says, I therefore grant summary judgment in the consumer's favor on the issue of whether Carrington furnished incomplete and inaccurate information. So that's done. Like, the jury will be told at the beginning of trial, Carrington furnished inaccurate, incomplete information. Now, your job, ladies and gentlemen of the jury, is to decide, did they do a reasonable investigation? And if they did not, what, if any, are the damages flowing from that? Now, let's look at this part 2. The reasonableness of the investigation, the judge tells us in this heading, is genuinely disputed, so that's not going to be summary judgment. So let's take a look at the law here. So under the section 1681 S2B, those obligations by a furnisher are triggered upon notice of dispute. So when you dispute with the credit reporting agency and then they go notify Carrington or Chase or Bank of America or Midland Funding or whoever it is, now that furnisher has obligations under section 1681 S2B. So what do they have to do? These obligations include a reasonable investigation, review all relevant information provided by the Consumer Reporting Agency. And I'll also say this, and they have to check their own records. They can't just ignore what's in their file. And then they have to report the investigation's results to the Consumer Reporting Agency, or if the information's inaccurate or incomplete, report those results to all agencies it's furnished. And they have to tell the credit bureaus, look, here's the information that needs to be corrected. And if they can't figure this out, then they're supposed to delete it, okay? So then we look at this Ninth Circuit case, Gorham, and they say, the pertinent question is whether the furnisher's procedures were reasonable in light of what it learned about the nature of the dispute from the description of the notice of dispute. Let me stop right there. Here's what they're talking about. If, let's say you do a super detailed letter and you lay out 27 items that are wrong with this particular account, and the credit bureaus pick a different item and tell the furnisher that, and the furnisher doesn't know what you actually said in your dispute letter, well, then they're going to be judged really by and large by what's in that notice of dispute from the credit bureaus. Okay. Now, here's the solution to it. Send a copy of your dispute letter to the furnisher. It does not trigger any obligations on its own, but when the credit bureau notifies the furnisher, then the furnisher, they've got to look at your letter also. And in the past couple years, we're seeing that typically the credit bureaus will go ahead and send your dispute letter to the furnisher anyway, okay? But not always, but usually it's a good idea to just send a certified mail copy of your dispute letter to the furnisher anyway, okay? Let's go back to the case here, this Gorham case. That court cautioned the fact that the notice determines the nature of the dispute to be investigated does not suggest it also cabins the scope of the investigation once undertaken. Their point is just this. We look at that notice of dispute, but that's not the end-all be-all, okay? A furnisher does have to use common sense. That's why they've got to look at what's in their own files to see. And the Ninth Circuit cautioned summary judgments on the question of reasonableness is typically the province of a jury. So you only grant summary judgment when there's only one conclusion about the conduct's reasonableness as possible. Okay, so the Consumer Reporting Agency forwarded the dispute, and the letters reveal the nature of the dispute was threefold. So here we have, let's go back up. I just want to highlight this for a second. Carrington did get the letters. Okay, so the credit bureaus did forward those letters on to Carrington. So let's see what the Morrises are alleging in their letters. They're saying it's inaccurate to report late payments because we're paying as required. Think about it this way. If you don't owe anything, you don't have to pay. So it's kind of hard to be late. And we surrendered this property. We supported or performed all obligations. And it's inaccurate to say that we still owe $455,000 and past due $72,000 since the debt was discharged. Now, the husband here attached the bankruptcy petition, confirmation order, confirmed plan, discharge order. The wife did not, but she said, here's the case number, here's the discharge. Look, it's usually a good idea to provide as much information as you can to the credit bureau. Now, sometimes there are reasons not to do that, but typically you want to give them all this information so that there's no excuse for the credit bureau and for the furnisher. Okay? And then here's what the judge is saying. The dispute letters contained enough information to alert Carrington to the specific nature of their claim. It's inaccurate to report a balance. It's inaccurate to report past due payment obligation because the personal liability was discharged. Okay? Now, what we have in this paragraph that's in green is this is Carrington's response. So they get their vice president here, Elizabeth Osterman, to say, here's what we did. We reviewed the credit reporting resource guide. That's the industry standard book. If you hear things called like Metro 2, that's what we're talking about. This is the industry guide that says, here's how you should report. Now, I'll say this. Courts are very, very, very clear. The industry guide is not the law. Okay? You know what it is? It's an industry guide. It doesn't prove anything other than this is what the industry says is the best practice. So she said, well, we looked at that and we looked at our own policies and procedures to see whether the trade line needed to be updated and how to report the delinquent loan. And we determined the property was not yet surrendered. And so we should continue reporting the loan balances due until they conveyed the property, in other words, like a quitclaim deed, or surrender physical possession. So what she's saying is we looked at it and we knew there was a discharge order. We knew everything that we've talked about in this case, but we decided in our own little brains that, well, since there wasn't a quitclaim deed or since they didn't convey physical possession, I'm not sure how you do physical possession of a house, okay? You know, like the keys, or do you have to like haul the house to Carrington's headquarters? I mean, what's the deal here? But she's saying because we didn't see that, we decided that we're going to keep reporting this information, which is just on its face completely false and bogus. Okay, now she didn't say that. I'm saying that. On its face, it's completely false and bogus. Every mortgage company knows it. We've been suing mortgage companies for this. I don't know, maybe 12 years ago was the first lawsuit we filed, 15 years ago. I mean, we've been suing them a long time for this. This is not rocket science. This is not something that's new, okay? So here's what the judge says. He goes, well, you know, that's cute what you're saying here, but Ms. Vice President of Carrington Mortgage, you did not expressly declare that you investigated the dispute that the loan had been discharged, and you gave no evidence to show that you investigated that issue, and there's no evidence that either your little industry manual or your own policies and procedures contain information that could allow its personnel to make that determination. In other words, what were your policies and procedures? Here's one thing. When we sue these companies, debt collectors, mortgage company, trucking company, whoever it is, they hate to turn over their policies and procedures. What they want to do is hide those. Say, oh, they're top secret. We can't let you see our top secret information here. And then they say, well, we followed our policies and procedures, which are top secret that we're not going to let you see. And so you should rule in our favor because just trust us. We consulted our ultra secret policies and procedures. And we did everything perfect. And the courts go, yeah, that's cute. But you got to like give up your policies and procedures if you want to rely on them. Okay. And then Carrington argues that the industry manual does not account for this scenario. And the court says, but that gap in coverage is precisely why a reasonable jury could find that simply reviewing the industry guide, which doesn't cover this, and your policies and procedures, which apparently don't cover this, was not a sufficient investigation. Do you see the absurdity of the way these companies act? They say, well, look, we consulted this secret industry guide, which, by the way, if you try to buy one, they won't let you buy it. Okay. And they act like this thing is so top secret. It's floating around on the internet, but they act like it's top secret. And they go, well, we consulted that, the all-knowing oracle. Well, what did the all-knowing oracle say? Well, nothing. Well, then we consulted our perfect policies and procedures. Well, what did they say? Well, we can't tell you. And the judge goes, well, a jury could decide that you looking at a bunch of blank pages is not really an investigation. All right, so the Morrises move for summary judgment, and they say the investigation is unreasonable because its conclusion was wrong. This is a subtle point, but we have to understand this. If we're doing cases under the Fair Credit Reporting Act, an investigation is not unnecessarily unreasonable. Think about how many negatives there are in there. Because it results in a substantive conclusion unfavorable to the consumer, even if that's wrong. Let me just put that in simple language. The fact that the credit reporting is false does not 100% mean that the investigation was unreasonable. This is not what we call strict liability. So the FDCPA, Fair Debt Collection Practices, that is what we call strict liability. In other words, if they get it wrong, they violated the law. Okay? But here, it's a negligence standard. So it could be the wrong result is reached, but the investigation was reasonable. So the court, as I have here in the red, says, look, they do not provide evidence to show what Carrington did or did not do. They did not provide argument to show policies and procedures are unreasonable, nor do they address what steps that the VP of Carrington declared that Carrington took were reasonable, okay? Or from the consumer standpoint, unreasonable. In other words, you've got to show all that in discovery. Take a deposition, get documents. You have to be able to prove this, not just say it. The most the Morrises offer are arguments attacking the credibility. And it sounds like her credibility is completely shot here, okay, and the weight of her testimony. But those arguments are for the fact finder. So in other words, those are jury arguments. Make those arguments to the jury where you say, well, think about it. I mean, what kind of investigation is this when you look at a blank page in this industry manual and you look at blank pages in the policy and procedure that they won't even put forth? Well, that's something you argue to the jury. Now, let's look at damages. And this will be really the last section we look at. So remember, on liability, the judge has said, I find it was inaccurate. I find it was incomplete, the credit reporting. But a jury will have to decide, was Carrington reasonable or unreasonable in their investigation? But now let's look at damages, because Carrington says, look, forget about liability. We win because there's no actual injury, no actual damages. Okay? That's their argument. Carrington says Morrises cannot make out a prima facie case. That just means that you hit all the elements required. Now, we looked up at the top of this at 4 elements, but there's always an element of damage. Okay? Because there's no scenario in which all negative indicators would have been removed from the loan's trade line. Now, I'll just tell you that that's a stupid argument. Okay? It's a common argument, but it's a stupid argument. They're saying, well, if you can't show that everything on your report would have been perfect, then you don't win. Okay? Let me give you an example. So we sue a nursing home, and they admit that they had a patient in the bed who could not stand on her own. They got her out of bed, took her in the bathroom, left her in there for 4 hours, and finally she tries to come out of the bathroom. She falls, breaks her hip, and dies. And they go, well, we can't be liable. I mean, yeah, we did a terrible job. That's malpractice. But you can't hold us responsible for it because she was not in perfect health. You see how stupid that argument is? Like, well, I'm not in a nursing home if I'm in perfect health. I'm in a nursing home because I'm not in perfect health. Okay? Well, here, you don't have to have perfect credit to get damages. And we're going to see, even if they're only talking about this particular trade line or account of Carrington, the account shouldn't have been on there in the first place. But even if it was on there, the fact that there's multiple false things on there, that can impact my credit. Okay, so if there are 5 false things on there and there should have only been 1, in other words, saying discharge and bankruptcy, well, you don't get to win on that, Carrington. Now, then they have an expert, and this is John Olsheimer. I'll tell you that I know John Olsheimer. I've known him for many, many years. He's very talented at what he does. I don't think that his argument here, at least as portrayed by the court, is accurate. So testifying deposition, the loan's trade line was updated to show what they sought. then the balance and past due amounts would be zero. That is correct. But there'd be a notation with the account indicating Chapter 13 bankruptcy. And the foreclosure notations would remain if they had actually been initiated. Well, I think that's incorrect on the initiated, because normally where that shows up is under sort of a general comment section, and that's what happened here. Well, if this happened 4 years ago and there's no foreclosure now, you can't just leave that on there. Okay, and the fact that it says Chapter 13, well, look, there's going to be a Chapter 13 on the bankruptcy report itself, unless this is very unusual. And then Carrington says the foreclosure and bankruptcy would have caused creditors to deny the application. Well, I think that that is wrong. Okay, even if we just accept what they said, it's wrong. Okay, now it's a clever argument. John Olsheimer made a clever argument. Carrington's made a clever argument, but ultimately it's wrong. But here's what they missed, and give credit to the plaintiffs and their attorney, because this is a very smart argument to make. The Morrises say, look, you forgot something. You forgot something really, really important. The loan would have been purged, in other words, deleted off of the credit reports if you had reasonably investigated the account, because you would have seen the date of first default. So let me talk about that. What's the date of first default? The date of first major delinquency. This is the trigger date for the 7 years for something to stay on your credit report. Okay, so you have you fall behind 30 days, then you catch back up. Well, that doesn't trigger 7 years on the whole account. It triggers 7 years on that one 30-day late period. Okay, but for the whole account to drop off, it's 7 years from the date of first major delinquency, which is typically 6 months of not making payments. And so if you go 6 months of not making payments, then that's going to be the trigger point for 7 years, and then it falls off. Another way you could think about it is 7.5 years from when you first kind of fell off the wagon here. Okay, so Carrington should have furnished the date they filed their bankruptcy petition, 2010. Now, I don't know, is that accurate? Should there have been stuff before? And look, this may not have been raised in John Olsheimer's deposition. He may not have been asked about it by Carrington or the other side. So I don't know. I'm going to assume this is Carrington's mistake here, but it's a big mistake. And so the plaintiffs go on to say, look, here's excerpts from that manual, remember, the industry guideline that Carrington was so proud about, and from Carrington's 30B6 witness. That's her corporate representative, testifies under oath. Mortgages argue that if he had furnished the bankruptcy indicators, the correct date of first default, then that would have caused the consumer reporting agencies purge the loan, so it wouldn't have been on my credit reports when you pull my credit. Now, a counter argument to this, and maybe it was made, maybe it was not made, but it looks like from the very next sentence here, Carrington does not directly address the argument, is did their letters bring up the fact that you had an inaccurate date of first default, date of first major delinquency? And there would be some judges that would say, well, you didn't raise that, okay? But in this situation, the judge is accepting it. So here's what Carrington responds. It says, a voluntary surrender in bankruptcy does not transfer ownership. Well, so what? I mean, we're not talking about ownership here. I mean, the ownership of the property is still in the name of the plaintiffs until it's foreclosed, or there's a deed, could be a foreclosure deed, quitclaim deed, whatever, deed in lieu of foreclosure. Until it's deeded to Carrington, it's still in the name of the consumers. So the judge says those authorities do not stand for a proposition. Creditor can furnish information about a discharge loan if the debtor maintains an ownership interest. And then Carrington provides no other authorities to connect those dots, nor does it provide any authority to show it could justify or that it could furnish just foreclosure indicators. Morris has raised genuine dispute of fact about whether the loan would have been purged had performed a reasonable investigation. Okay, now here's the next one. And in this, Carrington is right. And I suspect that John Olsheimer helped them with this. And he would know this very clearly. So they say, look, we're not liable for any damages from the credit denial because that occurred before our duty to investigate arose, or 2 later denials because you didn't plead them. Now, that second argument is a lousy argument, okay? So I don't think Alzheimer was involved in that one. And they say, look, the latter argument's non-starter. The Morses allege they were denied credit opportunities. They gave you evidence of this, so that's not even worth talking about. But this final paragraph is, finally, and really this is the first argument, Carrington argues it cannot be liable for damages stem from credit denial that occurred before its duty to investigate arose. So there's a general principle under the Fair Credit Reporting Act that says, and it's different if you're suing the credit bureaus under what's called an EB claim. We're not talking about that. We're talking about suing the furnisher under 1681 S2B. So let's say on January 1st, you get denied credit. And then February 1st, you pull your credit report. You see there's bogus information on there. So March 1st, you do a dispute. April 1st, it comes back verified. Well, you cannot go back in time to the January 1 denial because your damages flow forward in time from when the investigation was done improperly. Okay, so let's see what the judge says here. It says, well, look, Carrington cites some cases, Morris cites some cases, but we don't have to look at that. Plain language of the Fair Credit Reporting Act provides consumer may recover the sum of any actual damages. And I can tell you in 11th Circuit and most places that includes emotional distress damages. He sustained as a result of the failure of a person to comply with any requirement imposed on him or her under the Fair Credit Reporting Act. So Carrington has an obligation to do a proper investigation. When? When does that obligation arise? It arises when they're notified by the credit bureaus of the dispute. So that's the only time that their obligation comes into play and that their failure can create the ability to sue under 1681 S2B. So logically, any damages of Morses incurred from credit denial that occurred before Carrington's FCRA duties arose could not have been sustained by them. Thus, Carrington's entitled summary judgment on this narrow issue of damage. The rest of the case is about their arguing about whether to seal documents. You can read it if you want. Not really important for our purposes. I would say here's kind of the take-home message. If you've been through a bankruptcy, check your credit reports. Go to annualcreditreport.com. You can pull them once a week now instead of once a year. Once a week, you can pull Equifax, Experian, TransUnion. Look at your credit reports. Look at any account that was discharged. Now, we usually suggest give it about 60 days, 90 days after your discharge. But if you're a year, 2 years, definitely take a look. And look, even if you're 30 days, like go ahead and pull them. Take a look. See what's being reported, then you can track the change. Any account that's been discharged and not reaffirmed, because reaffirmed means you agree again to it. So then they would report it just as if you'd never filed bankruptcy. But if it's been discharged, does it show a zero balance? Does it show any late payments or missed payments after you file bankruptcy? Okay, because if you file bankruptcy and it gets a little complicated, but let's just make this super simple. Does it show any late payments after the discharge date? If it does, then that's going to tell you that that's probably wrong. Because if you owe nothing, how can you be late? Imagine somebody saying, well, John Watts is 4 months late paying me. Well, how much does he owe you? Nothing. Well, how can he be late if he owes you nothing? Okay, so that's one thing. Look at the payments. Look at the balance. Is it a zero balance? Look at the comments or the remarks. Does it say something like include in bankruptcy, discharge in bankruptcy? And if you see something that doesn't look right, then dispute it. Tell the credit bureaus why it's wrong. Attach your bankruptcy petition, the discharge order, all that sort of stuff. Send a copy to the furnisher. Do all this by certified mail. See if everybody fixes it. If they don't, then look at suing them. Now, if you want some help before you do that, get with a lawyer who sues under the Fair Credit Reporting Act. Some people like to do the disputes on their own. That's fine. And then meet with a lawyer. I'll just say this. Sometimes people come to us and they say, look, I've done perfect disputes. And we say, well, actually, you worded this wrong. We need to do another dispute. So, look, from a selfish standpoint, I would prefer people come to me and everything has been perfectly disputed, and all I need to do is file the lawsuit. That's easier for me. For a lot of people, though, it makes sense. If you're in Alabama, come to me. If you're in another state, go to a lawyer in your state that does this. If you can't find one, let me know. And have them help you do the dispute just to make sure it's done the right way, because we know what the judges require. Okay. And so we can read the statute, but we also know what the judges in our district or our circuit or even across the country, what they require in these things. So that's my encouragement to you. If you have any questions, feel free to reach out to me. My name is John Watts. I'm a lawyer in Alabama. You can reach me at 205-879-2447 or alabamaconsumer.com. If you like this, click subscribe. Feel free to share this, put comments, and I will catch you guys in the next one. And just a reminder, this case is Robert Morris and LaRonda Morris, and it's got a bunch of companies, but it's against Carrington, United States District Court, Nevada, April 23rd of this year. And we'll have this link up in the description so you can read this on Google Scholar absolutely free. And we didn't look through all this, but there are tons of footnotes down here, lots of cases, and you should be able to click on these cases on the Google Scholar version. Okay, thanks guys. I'll catch you in the next one. Bye-bye.